All right, it's 11:02, so we'll get started. Good morning. My name is Diana Morrison, and I am substituting for Larry Boras, who is on a much-deserved vacation. Welcome to NOWIC's first Monday Roundtable. Today's topic is HIPAA issues impacting on-site clinics, a review of recent HIPAA enforcement actions, and privacy and security trends. Well, we're thrilled to have you with us this morning for this timely and informative discussion. For those of you new to NOWIC, we are the nation's only non-profit exclusively supporting employers and union sponsors utilizing direct contracting strategies for on-site, near-site, virtual, and shared health and wellness centers. Our mission is to help expand your clinic's capabilities and access educational, benchmarking, advocacy, and purchasing support in this landscape of workplace healthcare. We invite you to mark your calendars for our upcoming lineup of webinars. Each session digs into strategies and real-world experiences from employers and healthcare leaders. We have webinars scheduled for August, September, October, and November. If you'd like to host a future roundtable or webinar, please reach out to Larry Boras. We're always looking to spotlight innovative worksite health models. Today's roundtable flow will look like this. First, we'll go around the room for brief introductions. Please share your name, organization, title, and a short description of your responsibilities. Then our expert, Stephanie Eckerly, will provide an overview of today's topic. After that, we'll open the floor for discussion, so feel free to ask questions, share experiences, and offer suggestions. And just a quick note, this session is being recorded, and we will share with all participants and NOWIC members afterward. So let's dive in. We now welcome our featured speaker, Stephanie Eckerly, to kick things off with today's topic on HIPAA's enforcement actions and trends in privacy and security, a critical area we manage as we manage protected health data within our clinic models. But before doing that, let's go around the room and introduce ourselves as part of the roundtable format. And feel free to unmute yourself in doing so. And I'll call people based on who I see on the screen. So Cole Williams.
Hi, Cole Williams here with Marathon Health. Good to be here.
Thank you. Danielle Metz.
Hi, I'm Danielle Metz. I'm the Director of Health Partners. We're located in Ohio and provide the occupational health services for the Honda locations in Ohio. So I oversee 5 on-site and 2 near-site clinics here.
Thank you. Emily Banta.
Hi, I'm Emily Bonta-Keither. I am a manager for Theta Care at Work. So we do occupational health, wellness, EAP services, as well as on-site, near-site clinics.
Thanks, Emily. Kendall Rosemeyer. Okay, moving on. Martha Stewart, or Shepherd, I'm sorry. Stewart. It just flows off the tongue.
And I can't cook or the flip. My name is Martha Shepherd. I'm a family medicine physician. I'm on faculty at Vanderbilt. CMO of the Metro Nashville Public School Teacher Health Plan and medical director for the 5 on-site clinics that Vanderbilt staffs and operates for Metro Nashville Public Schools.
Thanks, Martha. Rebecca Kohler.
Hi, Rebecca Kohler, Director of Client Services for Shafley Plan Management. I do the benefits for largely school and public employers, and we have on-site and off-site clinics that we manage.
Thanks, everyone. So now we'll hand it over to Stephanie. Stephanie?
Great. Hi, everyone. I'm Stephanie Eckerly with the law firm of Krieg DeVault and excited to be here with you guys today. Diana, can you see my screen?
Yes, we can.
Oh, perfect. Okay, for some reason it doesn't look like it on my end, but glad to know that's happening. So, yeah, today, first, I want to tell you, I know originally this was supposed to be about COBRA, but we had to have a slight scheduling change. So my colleague that's going to be talking about COBRA and clinics will be doing that here in the fall, and I know Diana and Larry and their team will be sending that out. So I'm sorry if you're here about COBRA today. I have an alternative, very exciting topic to talk about, which we were going to do in the fall anyways. So we're going to be talking about HIPAA, privacy, and security issues today for on-site health clinics, and spending a little bit of our time talking about artificial intelligence and its use within on-site health clinics, EHRs, and some of the protections that you guys need to be thinking about. Um, as Diana said, this is a round table, so if you guys have questions or comments, please feel free to chime in throughout or at the end, really up to you. And I probably have more information than we have time for in these slides, but I thought they would hopefully be a helpful resource for you and your team afterwards, as I know they plan on circulating the slides too. So some of these we'll spend some more time on, and others we'll go pretty quickly through. Um, as we get started today, I wanted to talk about a little bit just how HIPAA clearly is not our only law governing record keeping for on-site health clinics. So if you're working in traditional healthcare, just, primary care or a pediatrician's office I would take my children to, we're just going to think about really HIPAA and state laws and maybe a few others. But I think that for on-site clinics, whether you're near site or on-site, there's a lot of other programs from a privacy perspective we need to think about beyond HIPAA, like OSHA, EEOC, and ADA. Part 2, if you're providing substance use disorder. EAP programs sometimes even have their own state laws that they have to govern or be governed by, in addition to dealing with mental health records. And so it really becomes more complex, I think, when you're dealing with employer health. When you're trying to figure out what laws apply, these are the key questions that I've used, frankly, for years to try to figure out, okay, if we're not sure which laws apply, let's start answering these first. And then we're going to look at the legal framework that governs all of these. And so again, I won't go over all these, but just important that you understand this, whether you're on the employer side or the provider side. Similarly, understanding what services you provide are going to dictate the privacy framework. And this is, again, some of the services that we always want to go through when we start representing new clients to determine what's going to apply. So, for example, substance use disorder, you're going to have your Part 2 records, DOT physicals. DOT has a whole separate guidance on record keeping and privacy, workers' compensation, state laws. So, again, just going through those. I will not go over all these, I promise, but what I've done here for everyone in the audience is tried to put together my list of state privacy and security laws, in addition to a lot of federal laws that everyone should be looking at. And I tried to put links to most of it so you guys can use this as a resource, whether it's with your compliance team, your providers, your legal counsel. And so on the first page, since there's 50 states and 50 different state laws, I of course couldn't link all of those, but just kind of the general breadth of what state laws you should be looking at, in addition to potentially HIPAA if you're a covered entity, which we're going to talk about. On the second page, some other laws, the EEOC and ADA is going to be very important, but then depending on what type of entity you are. So for example, if you're a publicly traded company, you may have additional cybersecurity requirements. If you have European data or expats or locations in Europe, you may have GDPR. And then lastly, I put together a few different resources for artificial intelligence here that I think really everyone should be looking at, and we'll go over these in more detail. So again, wanted to buzz through these slides quickly, but wanted you guys to have this as a resource, as I know NAWHC tries to provide those to their members, so wanted everyone to have this information. So jumping into HIPAA, I think the first thing we need to think about from a HIPAA standpoint for occupational health providers or on-site clinics that are providing primary care or other types of care is whether HIPAA even applies. So for HIPAA to apply, you must be what's considered a covered entity. And a healthcare provider is a covered entity if they, one, provide healthcare, which I think all the providers on this call do. They transmit information in electronic form. But the last really important component is that the information is transmitted in connection with a transaction that HHS has adopted a standard for. And most of these are going to be billing a third-party payer, whether that's a private payer, Medicaid managed care, Medicare, some type of claims coordination, potentially even $0 claims, if those are done electronically through standard transactions. This is really, really critical because I feel like in my practice, a lot of my clients are covered entities because they are billing a third-party payer or interacting with the health plan in some way. Maybe they aren't billing a third-party payer. The employer is paying a per employee per month fee or other type of fee to the provider, but there is still a claims interaction there on the back end with the TPA that makes them a covered entity. However, a lot of our clients that are solely occupational health providers may not be conducting any standard transactions and may not be a HIPAA covered entity. Even if you do not think you are a HIPAA covered entity and you want to do a very careful legal analysis, you are still going to have other laws such as privacy and security laws in every state that govern you. So I always warn people, doesn't mean you don't have to abide by any laws, but we'll want to look at that. So here's a couple examples that I've come up with as it relates to the occupational health. So if a manufacturing plant directly hires a medical director, and they are only providing occupational health services paid for by the employer, the providers are likely not a HIPAA covered entity. And again, don't take any of this as individual legal advice, so you'll want to check on that. This is because they're not conducting those standard transactions. These health services are being paid for directly by the employer. However, if a manufacturing plant engages a hospital system to manage its occupational health, that hospital system is dropping claims. They're billing third-party providers or payers, I'm sorry. And so those providers in the hospital will be a covered entity, likely even as it applies to those occupational health services. My third example is a manufacturing plant that engages a third-party on-site employer clinic to manage primary care services and staff an occupational health clinic. That's really going to depend on the actions of that third-party on-site employer clinic. In addition to all these examples, the health plan is also going to be a covered entity, including self-insured health plans. And so you'll want to think about it from the health plan perspective too. And I am trying to watch the chat, but Diana, if you see anyone wanting to chat, if you want to jump into and let me know, it's kind of hard to watch both.
Sounds good, Stephanie. I'll do that.
Okay. So just going over a few HIPAA basics here, and then we'll skip to some of the more trendy enforcement topics here. But PHI cannot be disclosed to an employer without a HIPAA authorization unless an exception applies. If the provider that holds that information is a covered entity. And here's a few excerpts from the HIPAA final rule from 2000. I won't read these to you verbatim, but just thought they'd be helpful to have. So on this one, if you have a covered healthcare provider that's doing a pre-employment physical. So let's say the hospital is a covered entity, they're doing a pre-employment physical of an individual, then they would need to get an authorization to share those pre-employment physical results with that employer. So there's actually some very helpful guidance from HHS if you want to go back 25 years ago to find that. So instead, we've summarized it here for you. Skip over that one. One really important exception here is that records can be disclosed to an employer when healthcare is provided at the direction of the employer. So the employer is hiring that healthcare provider. It's to conduct, let's say, medical surveillance required under OSHA, and the results of that physical exam are only related to those surveillance requirements or workplace injury. And the employer needs that to comply with a federal law or similar state law. And most importantly, the patient has received a notice that the protected health information will be disclosed to the employer, or if there's an on-site clinic that the notice is in a prominent place at the location where the healthcare is provided. So for our clients that are on-site clinics, and we're probably more on the provider side, but also do some employer work, we always make sure we have that notice posted in addition to getting any patient authorizations to give the providers extra cover when they know that they're going to have to be disclosing information to an employer for that employer to comply with certain state or federal laws. There's also a separate exception for workers' compensation that's there in case anyone would like to review that. Again, here's more information on when a hospital can disclose a vaccination status to the individual's employer or to evaluate work-related illnesses. So again, this goes back to the medical surveillance issue. One thing I want to talk about before we get into some of the trends we're seeing is just special considerations. So really, regardless of if you're a HIPAA covered entity, if you have any mental health services you're providing, those are going to be governed mental health records separately under state law, and psychotherapy notes are specifically called out in HIPAA. Employee records should be kept separately than the health records. And if you're doing any work for dependents or incapacitated individuals, those are going to be governed a little differently under state law. And I'm putting a pin in reproductive healthcare records. We will get there. Okay, we're there. So reproductive healthcare rules. This has been, I would say, the #1 hot topic that we have had in 2024 and 2025 with a lot of my clients. This has, of course, been on the provider side, but even on the employer and health plan side. So there was, oh shoot, and that should be December 23rd, 2024. The reproductive healthcare rules came out last year, and the compliance date was December 23rd, 2024. This required that before reproductive healthcare information was provided for certain purposes and to certain entities, that covered entities received an attestation. So, for example, before reproductive healthcare information could be given out for health oversight activities, law enforcement, to coroners, you had to get an attestation that the information would not be used improperly. And really, for any request, you had to make sure of that. However, there's been a lot of litigation about this, and the reproductive healthcare rules were vacated in a decision called Pearl versus U.S. Department of Health and Human Services. This was a federal court out of Texas that in June vacated the reproductive healthcare rule. And I think to some people's shock, this has nationwide impact, even though it was only one court. So the appeal period is not finished running, but I think most of us in this area do not expect HHS to appeal this ruling, although it could happen. But for right now, the reproductive healthcare rules are vacated. So at least for us, we are advising our covered entity clients that they currently do not need to use attestations or abide by the vacated portion of those rules. And there's a fact sheet there that goes through the reproductive healthcare rules, but also has HHS's statement on the Pearl decision. I think the appeal period runs August 18th or so, so we are watching that carefully to see if there is an appeal or if there's more guidance or additional proposed rules from HHS. So that has been one of the #1 things that we have been working through with our clients. So happy to answer any additional questions about reproductive health care. Another one that everyone on this call, if they're governed by HIPAA, should be looking at is the cybersecurity proposed rules. So there was a notice of proposed rulemaking in 2024 to strengthen cybersecurity requirements under HIPAA. This specifically actually imposed additional requirements for group health plans. It imposes increased requirements for contingency planning and incident response planning, compliance audits, risk analysis, something called a technology asset inventory. And it really even went into some more nuanced detail on certain cybersecurity efforts like multi-factor authentication. We do not have a final rule yet from HHS, although I would expect that sometime soon. And so once that final rule comes out, assuming there is one, we'll watch that carefully as it really will impact any healthcare provider that's a covered entity, as well as their business associates. So your TPAs, your PBMs, anyone like that may also have to comply with the increased cybersecurity requirements. And we'll probably assuming there is a final rule, be providing some more detailed education on that, because we could spend honestly several hours on it. However, if you are planning, I would say from a budget perspective and an IT perspective, and with your security officer for what 2026, 2027, 2028 will look like, I would go ahead and review that notice of proposed rulemaking or work with your counsel on that just to think about what additional investments you may need to make from a cybersecurity standpoint to comply. Another hot topic, and this has been one that's been going on for years, is the Right of Access Initiative. So under HIPAA, covered entities have 30 days to grant patient access to records. It can be extended to 60 days. And most states also have a very similar requirement, sometime with a shorter time period. And we have a lot of attorney generals enforcing this. And so one of HHS's really big enforcement actions over the past several years has been over right of access to records for patients. If you get a patient request, it is absolutely critical that you comply with that really as quickly as possible as it relates to a records request, and not just within 30 days, especially if you have a patient portal where you're pushing out data. More information about the HIPAA Right to Access Initiative and individuals' rights under HIPAA are there. At that last link, I would say too, one thing to think about that is if you feel like you need to deny a patient access to their own records, maybe you're worried about patient safety, you really need to look carefully at the procedural rules on how you can deny that and the reasons why, both under federal and state law. The last hot topic before we get into some state laws and actual enforcement actions is immigration and ICE enforcement. This has just been a really significant one for a lot of our clients, especially I would say in rural areas. I think when this first came out, no one really knew if ICE was going to be showing up, but we have seen it happen throughout several communities. Although I don't think, not so much in healthcare facilities for on-site clinics. I'll be honest, I haven't seen it yet there, although I think it's one that everyone needs to be prepared for. And so this is something I think we need to think about both from a HIPAA and privacy standpoint, but really a staff training standpoint. So who's at the front desk in your on-site clinic, especially if it's a near-site clinic and you don't have to walk through the employer's office to get there. So really working through this issue with your counsel over when and even if you can disclose any patient information to ICE, and if so, what type of subpoena do they have to have? If anyone's interested in that, we have separate guidance and a presentation I'd be happy to send to you if you want to email me on that, because here we just, from the purpose of this presentation, just went through the HIPAA permissions that may apply if ICE shows up, but there's some specific nuances there with the type of subpoenas and warrants that ICE can issue. We'd be happy to send out. In the chat. Nope, I think we're good. Okay, so before we get to state laws, I just want to go through a few other enforcement actions. I'm sorry, I've got multiple screens here if you see me looking around. And so from an enforcement standpoint, where we're really seeing HHS go after covered entities, and it's not just large covered entities, and it's not just covered entities, it's business associates too. So again, your TPA, for example, that may hold your data is, and I'm not picking on TPAs, actually none of these that I'm going to talk about here involve TPA, but one is the deletion of electronic PHI. So we've had a few cases where we have had an unauthorized third party that has gained access to a cloud or database that has been able to delete protected health information. So even if the protected health information isn't stolen or sold, the fact that you no longer have that PHI can be a HIPAA violation. Another one is just ransomware is continuing, and phishing emails, threat actors. That is probably where we see the most enforcement actions. There has been an ambulatory surgical center, Warby Parker, several business associates, a few different health systems that have all had issues with unauthorized third parties gaining access to email accounts or the cloud or databases. And one thing that really resonates from a lot of these cases is there's an issue because the threat actor gained access to the database, so it was no longer secure. But one of the broader issues is a lot of these entities may not have had an annual risk assessment. They may not have had annual workforce training, or they may not have really thorough policies and procedures. So a lot of the enforcement actions about these cybersecurity breaches and phishing, you'll see that there's problems. Let me move this over. There's issues because of the actual security concern, but also because of what they're not doing on the HIPAA compliance side. But let's go to state laws here for a second. How am I on time? 12:28, perfect. Okay. So, of course, with all the different states, this can be really hard. And I think especially in the Worksite Health Center area, because a lot of our on-site clinic providers operate in 10, 20, 30 states, and a lot of employers operate in all 50 states nationally, 10 states. And so not only do you have to have a handle on federal law, but also on the different state laws. One thing that just happened fairly recently is there's been a consortium of privacy regulators that have formed a group to coordinate both resources and expertise and violations of law. So there's the member states listed there, and a link from the California Attorney General's website about this bipartisan consortium. I would say one thing for those on-site clinic providers and employers operating in multiple states. If you report a data breach in one state, they will likely notify the other states of that. There is a very coordinated effort. So when we have a client who maybe has a data breach where 5 different states are impacted, but let's say only 3 states actually require notification to that attorney general, we will sometimes advise to report in all the states just because we would rather be the ones reporting and being very transparent since we know the AGs are coordinating. This is not the case all the time, so you'll want to consult with your individual legal counsel about breach notification requirements and best practices. But just beware that even before this consortium, the state AGs were coordinating, but here it's much more of a concerted effort. Again, as we just talked about, each state has its own laws, and there's different state breach notification laws. One thing I think that's really critical for employers to know here is even if your provider is not a covered entity and you don't have to report to OCR, again, you may still have to report a data breach or a privacy issue to individuals and state attorney generals. And the timing really varies there. There's a few states that it's as soon as, 10, 14 days, and then others that are 60, more in line with HIPAA. Here's a list of other laws we see that was also talked about on one of the prior slides. But one thing, since we're talking about hot topics today, is I want to spend a little bit of time talking about artificial intelligence. So artificial intelligence is something that we are getting approached about all the time from a legal and compliance perspective. And again, this is another one of those topics we could spend an entire hour or two on, and have done so. So happy to provide more information on that. But what I always tell my clients for on-site clinic providers and employers that if you think your employees are not using AI, they probably are. When my clients start talking to their nurses, their physicians, operations managers, typically there is some type of AI use, at least in some of them. And so we're telling our clients right now, go ahead and get that governance framework and the policies in place for AI and figure out what laws apply. So that way you can take a proactive approach rather than reactive. So here's a couple examples of laws. In California, there's an artificial intelligence and healthcare service law that applies to even physicians' offices or group practices. So think about an occupational health provider providing healthcare services. This may apply. It's not just those hospitals or health facilities licensed by the state. But here you have to have certain disclaimers and notices and everything if you are using AI at all that is not reviewed by a human healthcare provider, which is funny that we're now making the differential between human and non-human healthcare providers. But it does not apply to administrative matters. So it's really clinical information when AI is being used for that. So if you're in California, you're going to want to take note of that. And also in California, I would advise you to look at the Attorney General's new legal advisory on existing California law to AI. And this goes into a lot of healthcare issues too. And I should add, because everyone on here has such national reach from an employer and provider perspective, it's even if you don't have a physical location or providers in California, if you have employees in California and telehealth services are being provided there, you're going to want to look at this there too. And here's just some excerpts from the California AG's legal advisory. Illinois law is another one that we're seeing. So in Illinois, there are really two laws we think about for AI, and one of them is the Biometric Information Privacy Act. Although this is not AI governing AI directly, most of the litigation right now surrounds AI as it relates to this act. So because biometric identifiers such as face geometry or fingerprints or voice prints are used in AI, you see a lot of litigation there. The other one is the Artificial Intelligence Video Interview Act, which applies to all employers that use AI technology to analyze applicant interview videos for Illinois-based positions. Although we are talking about healthcare issues here, because of the interplay between employment decisions and worksite health centers, I wanted to highlight that in the slides previously where we had all the different laws governing AI or an example of those, there was some information about EEOC statements on AI too, and there has been some enforcement actions on the EEOC side as it relates to the use of AI in the employment and interviewing and hiring and firing context. So you'll want to take a look at those too. If you have providers using AI, we recommend that, not only do you have a policy that applies to the entire company as it relates to the use of AI and a governance framework, but you have a specific section as it relates to providers that you're really training them on, such as, vetting both the input and the output from AI, independent medical judgment, not using it for any research, looking at the discriminatory or potentially discriminatory effects of using AI. And so there's a whole list of things we really should be thinking about. So that's probably the biggest hot topic we've seen is on the AI side in healthcare. And I know that was a lot, and I wanted to leave a lot of time for questions. So happy to go back through any of the slides that we kind of skipped over that I gave you just as a resource or provide information on other items.
Thanks, Stephanie. So now that we've concluded, let's go around the table to see if there are any questions, comments, or takeaways from today's session. So I will call on you as I see you on my screen. So Martha, do you have any questions, comments?
I did have questions about health plan data research. I think people have no idea how much access their employer has to their health plan data. But I do research through Vanderbilt. Every project I run through the IRB office, if it's de-identified aggregate, it's a non-research determination. It's no big deal. If there's PHI, a bunch of questions begin to be asked. And in the end, I end up with a research exempt determination. And I can't remember the line of the clause that I use, but being a covered entity is part of that. I think my question is, Vanderbilt's a big place and the legal department's constantly changing over, and it's like I'm re-explaining this every time. Is there some reference that I can use that clearly outlines the access that employers have to the health plan data and how it can be used for research?
Martha, that's a great question. I don't think I have anything specifically research related, but let me take that offline because it's pretty specific and get back to you on that. I would say the other thing that I think is, because a couple things. One, I think a lot of privacy and security attorneys' research is not top of mind a lot of times, so you are having to constantly re-explain it. And then especially as it relates to health plan research, people don't think this happens, and it does. I would say the other thing that's really critical, and I think you get this, but to make sure everyone else does, is to really understand what is de-identified information. I can't tell you how many times I've had providers or health plans say, oh, this information's de-identified because I took out her first and last name, or I just use her initials with only her, you know, zip code. Well, that is not de-identified either. And so HIPAA has a really, really strict definition of what is de-identified based on the removal of 18 identifiers or getting a expert opinion for de-identification, which I'm sure, Martha, you guys clearly understand that based on what you just said, but for everyone else out here, you'll want to be really careful. But yeah, let me circle back with you on the research as it relates to health plans, because I do not have something at the tip of my fingers that I can come up with, but I might be able to.
Great. Thank you. I appreciate it.
All right, moving on. Rebecca Kohler, do you have any questions or comments for Stephanie?
Yeah, I'll turn my video on here. You had mentioned the deletion of HIPAA. So the fact that we no longer have PHI, we deleted it because it's still in the cloud. TPAs can still gain access and it could be a HIPAA violation. Did I understand that correctly?
So are you stating that, well, there's a couple, let me make sure I understand the question, but also comment.
Okay.
So under state law, there's various record retention requirements, state and federal law, actually, depending on the type of records. So under OSHA, there's requirements. Under state laws, there's requirements for physicians. If you're complying with those record retention requirements, you legally can delete data after a certain period of time. Where there's an issue from a HIPAA perspective is when there's an issue with integrity or deletion of data that should not have been deleted. So you have a healthcare provider that maybe had a cybersecurity attack. They've only had that data for 18 months and it all gets deleted. That is going to be a HIPAA issue right there.
Okay.
As it relates to, I think what you're asking is, I think you made a really important point. I have seen providers that thought they have deleted data, right? But they have also have a cloud that multiple people can access, like TPAs and PBMs and everything, where maybe the data is not deleted there, right? And so I think you really do need to look at where all your data is, who has access to that, and who owns that storage of the data to be determining when it should be deleted and who should have access. A lot of times with, for example, TPAs, what we see with on-site clinic providers and employers is you're going to have data sharing agreements. And sometimes there'll be like 3, 4, 5 parties. You've probably seen those really complicated ones where the data actually goes to the TPA and it becomes their data as the business associate. Once it becomes their data as the business associate, or they're able to download it onto their own systems, I guess I should say, that access and how long they keep that and what it's used for should really be governed by your data sharing agreement, right? Can they only use it for the purpose of providing services to the employer? Can they use it for their own research purposes? Can they de-identify it? So I don't know if that answered your question directly, because there seemed to be a little bit of a crossover between deletion and TPA access.
I actually just wanted that clarification. So that was very helpful. Thank you.
Mm-hmm.
All right.
Can I add one thing to that? Sorry, Diana. I would say too, one thing that's really critical for this group is really all data sharing. You should either always have a BAA, and if a business associate arrangement is not appropriate, you need a data sharing agreement. I always advise my clients, like, please never share data with third parties with it, doing that analysis as to whether a BAA or data sharing agreement is required. And if a BAA is not, you're still going to want something in writing governing the use, access, and deletion of that data.
Great. Anthony Mucci, do you have any questions, comments?
No, thanks for the presentation, Stephanie. As you were describing what's needed in terms of occupational health services and letting patients know that their data may be shared, one of the challenges that on-site care clinics have are sort of avoiding the perception among prospective patients that employers may have access to their data. Now, obviously, in the case of occupational health, that's the case. But where you have centers that mix those services, I'm just curious if you've if you've come across any situations where that's been a concern to clinic operators and how they've managed that to avoid giving the impression that all data is shared with employers.
Oh, yeah, Anthony, that's such a great question and topic. And I think, Dana, we may have touched on this in other presentations and done like whole presentations on this. So we do have a lot of clients that provide both occupational health and primary care at on-site clinics. And, they honestly deal with it in a variety of ways. One of the most, I would say, conservative, but also a very good practice is I have some that actually use two different occupational health records, or I should say electronic health records, one for occupational health and one for primary care. And they will have completely different sets of forms. I even have some clients that they have their occupational health providers and their primary care providers. But most providers are not doing that, right? And so I think that's where the patient communication is really, really, really critical here. And so we usually really try to, one, think about at the beginning of the encounter when the appointment's being booked, trying to classify it from the outset as to whether it's occupational health or primary care. And then I think really emphasizing the privacy that's given to those primary care, mental health, acute care records as far as, this is not occupational health. We will not be releasing this information to your employer under any circumstances, nor will we ask you to do that really under any circumstances. However, if it's for occupational health, here's all the reasons that it will be released. And I've actually, when we've done authorizations for release of information, or Anthony, if you're familiar with like the consent for treatment, payment, and healthcare operations, we've actually been differentiated in those legal documents, like, uses for primary care records versus uses for occupational health. But I do think there's a big trust issue there with patients, and a lot of it goes to kind of the communication on the provider side too, as to what will be shared.
Sure, makes sense. Okay, thank you.
Mm-hmm.
Cole Williams, do you have any questions, comments for Stephanie?
Yeah, I think Anthony's question kind of went to where I was going to go, but now after I heard you guys talking about it, my question, Stephanie, would be, what about if during a primary care visit there is, well, no. What about if during an occupational health visit there is personal health concerns that come up and that information is then needing to be shared on the primary care side? Does that information still need to be, would that still be relevant for that actual visit on the occupational health side? For instance, let's say that someone comes in for a regular surveillance exam and it's discovered, oh, I went to the doctor or whatever, and I realized that, or I was told that my blood pressure's up, and I'm also pre-diabetic. Would that information be critical to be kept in the occupational health visit, if it had nothing to do with the actual surveillance exam? And then can it be shared? I may be asking a whole bunch of questions at once, but I guess that's where I'm at. Let me just stop there.
Yeah, I mean, it's so fact sensitive for all these. So, a couple things. My answer may be long too. So, I think one, for your providers out there from a risk management perspective, it's really critical that they keep accurate records. So the occupational health provider may think, oh, the fact that they're pre-diabetic, or, their blood pressure is XYZ, or they came in or starting to talk about their depression, may not be important from a whatever, let's say they're doing like a hearing test, right? Something that really wouldn't be related. I think if the patient talks about that with a provider, from a provider standpoint, it's really important, because if that provider doesn't reflect it in the record, it's like it never happened, right? And later on, the provider may say, no, we did talk about this. I told this person they really needed to go to their primary care doctor, because that is a big red flag, right? If they took their blood pressure at home and it was whatever. If that's not reflected in the record, and then there's later on an issue, that patient may say, I told my provider about my blood pressure. Provider is going to say, and I told them to go see their primary care physician or a cardiologist. But if that's not in the record, it's like it never happened. So setting aside privacy and security concerns from a record keeping standpoint, I think it's important. And from a malpractice standpoint, to protect your providers, And even from a patient access to records, if the patient can have access to their records, I think it's important to reflect what actually happened during that appointment. I think though, from a privacy and security standpoint, well, from a privacy more so, that's where your providers really need to understand how your EHR works and everyone else, does too from an operations standpoint to see, for example, within the EHR, are there areas where you can put, role-based access, right? Where maybe employer doesn't have access to all the clinical notes that were taken, only to the report on the medical monitoring and medical surveillance. And so I think that's where that's really critical to understand, what does the employer actually have access to versus what can we give certain roles access to? Because I hesitate, Cole, to state, don't have the provider put everything in there because of that. Now, within that record, if there's a primary care section and an occupational health section, and the provider can access both, that may be one way to slice and dice that. But I think it's really going to depend on how that EHR is set up. Does that help at all?
Yeah, I think toward the end there, you're getting to where I was going. Yeah, because the main concern comes in is, and employees will bring this up, like, okay, in this occupational health visit, you guys saw that I had high blood pressure and I'm pre-diabetic. It came out, but is my employer going to need to know about that? Is my employer going to have access to that information because it's not specific to my occupational health visit? And so, yeah, so I think you answered my question.
Yeah, and really, I would say most of the clients I work with, the employers do not have unfettered access to the EHR, where it's like someone from HR can just log in and see like all the stuff I talked about with my occupational health provider. So I think it's really understanding what that access looks like and how you can control that on the provider side is really, really critical.
Thank you.
Moving on, Danielle, do you have any questions or comments?
I think a lot of my questions were just answered by a couple of other folks. We are in our on-sites and near sites, provide we don't provide primary care. However, we do have what we break down into occupational health services and then what we call personal health services. I'm not sure how that would translate into terms that you might use, but we do non-work related care as well. So we're already kind of in a constant mindset of protecting data and what is HIPAA protected, what is not, what belongs to the employer, what doesn't, because we are operating with both types of health information on the same people already. And now we're talking about potentially adding primary care. The employer is talking about potentially being interested in that. So we're thinking about, how's that going to evolve even further from what we already are kind of constantly managing. We run two EMRs now, one that belongs to the employer and one that belongs to us. So neither one is suited for primary care. So would that be a third or I don't know, all the things that we are thinking.
Yeah, usually, so I don't know, are you able to share, do you mind sharing, like, what is an example of a personal care visit that's not primary care right now?
Um, so I say not primary care, as in we do not have primary care physicians, nor are they following patients in a primary care fashion. But we do have any of the employees are able to come in to our clinics if they are at work and having a non-work related issue. So if they have a headache, if they have abdominal
Yeah.
issues, whatever.
Nope, that makes sense. I usually think of that more like an acute care, but yeah, personal care too. I would, yeah, I don't think you need a 30 HR. I'd probably, whatever if you start doing primary care, I'd probably lump what you're calling personal care now in with that primary care, right? It's not information that the employer should have access to. It actually could lead to, if someone comes in and is complaining of constant heartburn, it could be an issue that could be solved once you start getting into primary care and chronic issues they may be having. And so usually, if there's primary care being provided, I see the acute care, as long as it's not workers' comp, illness, injury related, lumped in with the primary care then, because it is not information the employer should have access to unless it ultimately relates to the workplace injury or illness or, the medical monitoring and surveillance.
I guess I do have one question. I think you maybe alluded to that in your last statement. Our providers are somewhat hesitant at times to do screening exams that they're asked to perform. And let me give an example. For our employer has firefighters. And so they're asked to perform a firefighter physical. And inclusive in that is an EKG, a chest X-ray, and prostate labs, PF labs. And they get really hesitant about performing that, because if there are abnormals that aren't related and they refer them back to their primary care provider, they don't follow up. Where does that leave them? So I think you were talking about this. If they document that they've recommended the follow-up, is that pretty much where the liability ends with them? Or
Yeah, honestly, it's going to be really fact sensitive on that. It really gets into kind of the medical malpractice. Like you said, the liability. Is there a physician-patient relationship formed there just by doing a medical surveillance exam? And I think that's where that record is absolutely critical. If they have test results that come back and clearly they should be seeing a cardiologist or a primary care, they recommend that, but they don't follow up with them. I think having a really careful discussion and note in the record that recommended they follow up with their primary care, that they see a cardiologist, patient said they don't have one, we'll be giving the patient referrals, letting the patient know, that I'm not their primary care physician. We have even drafted for some of our occupational health providers that are only doing occ health, basically patient notice. So even when you're providing an occupational health exam, you should still be getting a consent by that patient in order to conduct the exam and talking through it. And we even try to put information usually in that consent and notice to the patient about the occupational health exam that they are doing or not doing exactly what you said, right? That they will not be following up ABC on these issues. So I've also seen occ health providers give a note printed off to the patient and put that in the record too about follow-up if there are test results that need to. So I think that just depends on the type of occ health. I also think it depends on your state laws. I think you're going to want to have legal counsel take a look at how is that physician-patient relationship established? Kind of where is that liability under state law? Because that's where most of that's going to be governed too. But I think it's really the patient communications up front and in the EHR.
thank you.
Michaela Chavez, do you have any questions or comments?
Hi, everyone. Yes, thank you so much, Stephanie. This was actually incredibly informative. I'm new to my role, and it's incredibly intimidating. So in this situation, I have actually two questions, and I'll start with the first. If we don't have time for the second, that's fine. Regarding the reproductive healthcare rule, we were advised we updated our notice of privacy practices, and then with these, these ongoing lawsuits pertaining to that particular rule, we were advised to hold on that update. I do know that there's a compliance date coming up in the new year for updating your notice of privacy practices. Would you say that it's good advice to just go ahead and get those published, or should we continue to wait to see what these rulings indicate?
On the reproductive healthcare rules side only, as it relates to what you can do that information, I would hold. The appeal period runs here in just a couple weeks. HHS hasn't appealed yet. There's interveners that wanted to appeal, but they've not been given the right to intervene. And so, I mean, assuming this doesn't go anywhere, you don't need to do that. Now, there were other NPP updated dating requirements for like substance use disorder and some other things that were not vacated by the Pearl decision. So you still need to move forward with those. Those were not impacted. And I'm happy to share more in detail if you want to reach out as to what was and wasn't on that. But on the solely reproductive health care attestation things, I just hold on that. I have clients already taking them out. For the ones that did already publish it, basically, unless there's an about face from HHS or a court on this.
Got it. Thank you so much.
Yep.
Second piece is regarding actually release of records. So much like Danielle mentioned, our particular area offers acute care visits as well as occupational medicine. And we've been working our way through our release of records, again, sort of revamping that process and running up against a lot of different information as to what can and cannot be released. So on the acute care side or primary care, however we want to refer to that, that's easy, right? And so when we get to the occupational side, we're kind of getting mired down in terms of so many things. Is it a survey? If it's a surveillance program, are we allowed to release those records to the patient, or is it something that they have to request through the federal government? Things like that. Do you have any insight into that at all?
Because you guys are going to be governed by federal acquisition regulations and you're going to be in a little different place than OSHA, I don't have any specific comments I can give you on that. I would need to look into that, other than I do think you're going to need, it's kind of like the beginning of the presentation when you're like break down the services you're providing, and then we're going to have to look at each applicable law. I think for any federal contractors out there, it's going to be different position than your normal kind of OSHA requirements for that. And then I think the other thing is, even on the primary care and acute side, remember, you're going to need to really think through those records if they have not just substance use disorder, but communicable disease or mental health records in them too, because under a lot of state laws, there's additional requirements there. But yeah, sorry, I wish I had a really easy answer for you on the federal side, but I do not on that one.
No problem. Thank you so much. I appreciate it.
Yeah. And Diana, I'll get you my slides too after this, so you can send those out.
Great. Anthony, were you going to say something? No? Okay. Last, Tanya Horton, do you have any questions or comments for Stephanie?
No, Stephanie, I just wanted to say it was really great. I'm also relatively new to my role, so you hitting on a lot of the important issues that we're all facing.
Tanya, are you in Indianapolis by any chance?
No, I'm actually
I
in
know
New
Marathon's
Jersey.
headquartered there, and I'm in Indy,
Yeah.
so we can grab lunch. Yeah.
No, I would have loved to. No, I'm in New Jersey. Yeah.
Okay.
Okay, so if any ideas or resources come to mind after today's session, don't hesitate to follow up with us via email or Stephanie, or go to our NOWIC LinkedIn group or message board on our website. A reminder that today's session has been recorded and will be shared, including the slides, with everyone that joined this roundtable. And on behalf of NAWHC, thank you to Stephanie and all of you on the call for joining us. Have a great afternoon.
Thank you. Bye.
Bye-bye.